Good morning. We are now live streaming on YouTube and on the record. I am Judge Leslie Kim Smith. We can call the first case.
All right, thank you, Judge. Calling case number 25007-298 NI D'Amico Knight versus Alan Bradley et al.
Good morning, Your Honor. Caroline McGovern on behalf of the defendant, Alan Bradley.
All right, and this is your motion for show cause?
It is, and just so the court is aware, I did receive the records from Esurance, so the motion is only going forward as to Parkwood Open Imaging and the Center for Preventative Medicine. And by way of further update, we did pay an invoice for Parkwood's records back in December, but we still have not received them. They were served a copy with this motion. And then as to the Center for Preventative Medicine, that invoice was just paid on January 14th, and that usually takes about 7 to 10 days to process. So we're still waiting on those records as well.
All right, so at this time, how do you wish to proceed? Would you prefer to adjourn the motion over, or do you want to have the matter scheduled for a show cause hearing?
I'm thinking we do a show cause hearing like 3 weeks out or so, just to give them some time to get us the records, and hopefully we won't actually have to go forward.
All right, so your motion is granted. The matter will be scheduled for a show cause hearing. Can you tell me how far out you'd want to have the show cause hearing scheduled?
I would say 3 weeks.
All right, 3 weeks would put you at February the 6th, 2026. And do you want a 9:30 or 10:30 time?
9:30, please.
9:30 a.m. Just make sure when you file your order for show cause hearing that it has the contact information to join Zoom.
Of course, I will do that. Thank you, Judge.
You're welcome. Have a good day.
You too. Bye-bye.
Thank you.
Calling case number 24018-265 NF Michigan First Rehab versus Allstate Insurance Company.
Good morning, Your Honor. Gina Smith-Galan here on behalf of Allstate.
All right, and this is your motion to extend discovery 60 days, correct?
Correct.
All right, and I did not notice a response from plaintiff.
I didn't receive one either, Your Honor, but
Okay.
stranger things have happened, and I didn't know whether the court received one.
I did not. All right, now I was looking over your case and it looks like you went to case eval December 22nd. There is a motion for partial summary disposition that's scheduled for February the 4th. Do you
Correct.
want to extend or adjourn the motion to a date and time 60 days out so that you have an opportunity to finish discovery?
Yes, that would be good.
Okay, so what I'll do is I'm going to grant your motion. I'm going to extend discovery 60 days, so that would put you at March 16th, 2026. So I thought perhaps I could schedule your motion for partial summary disposition maybe 2 weeks after that.
That makes sense to me, Your Honor.
Okay,
So should I make an order with the motion granted with the extension of discovery for up until
Well,
March 16th,
just-
2026?
let me finish getting you some dates first.
Okay.
Okay, so your motion is granted. Discovery is going to continue until March 16th, 2026. Your settlement conference that's currently scheduled for February the 4th is also going to be adjourned. It will be adjourned until March 31st, 2026 at 10:30 a.m. via Zoom. Your motion for partial summary disposition will also be adjourned until the same date and time. So if you will renotice your motion for partial summary disposition for the March 31st, 2026, 10:30 via Zoom. And I'm going to move your settlement conference over to that date and time.
Thank you.
All right, anything else?
That will do it.
All right, have a good day.
You as well.
Thank you.
Calling case number 25003-8609, NI James Underwood versus Elisa Stanley.
Good morning, Your Honor. Attorney Dean Latowski on behalf of
Oh,
Defendant Alyssa Stanley.
oh, there you go. All right. And this is your motion adjourned scheduling order. You want to move to track 2?
It's gonna be a movement to track 3, Your Honor.
Oh, track 3. Okay. I'm not inclined to push you all the way to track 3. What I'm inclined to do is you were basically asking for some more time to do discovery. So I'm going to I'm going to extend discovery until April the 24th, 2026. And then I'm going to move case evaluation to May of 2026. So that should give you time to take care of all of your discovery issues. Make sure you do so because I'm not likely to allow for any further adjournments.
Understood, Your Honor. That's April, you said 4th or 24th?
April 24th, and that's part of the track 3. So discovery is going to be continued to April the 24th. In terms of your witness list, do you want your witness list to be extended to February the 20th?
That would be great, Your Honor,
Okay.
because I'm taking plaintiff's dep next week, and I'm gonna want to update any witnesses based off that deposition. So if
Okay.
you don't,
All right,
that'd be great.
so the witness list is now extended until February the 20th, 2026, discovery to April 24th, 2026, and case evaluation month is moved to May of 2026. Make sure your order includes all of those dates.
Understood, Your Honor.
All right.
I'll get that order out today.
Okay, have a good day.
Thank you as well.
Thank you.
Calling case number 25004-931 CK Cosette Ellington versus State Farm et al.
Anyone here on the Cosette Ellington matter? Oh, I'm sorry. Good morning. Oh, you have to unmute your microphone.
Good morning, Judge.
Good morning. And can you place your appearance on the record?
Yeah, Attorney Isaiah Lipsy, but I'm actually here on the Breon DeWitt matter,
Oh, okay. Well,
and they popped me in.
okay, that isn't the case we called, so you can just
Exactly.
cut your video, mute your microphone.
Okay,
All right.
thank you.
Anyone here on the Cosette Elliott matter? We can cancel this motion.
Okay. Calling case number 25006-449 NF Go Beyond Physical Therapy versus Auto Club Insurance Association.
Anyone here on the Go Beyond Physical Therapy versus Auto Club Insurance Association case? Kim, you can cancel this motion.
Okay. Calling case number 24018-097 NF Breon DeWitt versus Allstate Insurance Company.
Morning, Your Honor. Connor Hoffman on behalf of Defendant Allstate.
Attorney Isaiah Lipsy on behalf of Breon DeWitt.
All right. This is plaintiff's motion to compel deposition of non-parties.
Actually, it's a defendant's motion, Your Honor.
I'm sorry, okay. And you're trying to get the deposition of 2 police officers?
Correct, Your Honor. Just to clarify for the record, so we have 2 police officers, Marcus Sheffield and Raymond Wright.
Right.
And we were able to get a date for Mr. Wright's deposition, but the Detroit Law Department ended up having to cancel that due to an emergency. And we reached out for dates and we haven't gotten dates. And Mr. Sheffield apparently no longer works for the Detroit Police Department, and we were just asking for the information they have as to his last known address and whatnot.
Okay.
And then also just to extend the discovery cutoff and the summary disposition cutoff.
All right. And Mr. Ipsy, it seems to me you filed a concurrence. However, you're requesting that discovery be extended for 45 days and that the discovery be extended 45 days and that you were supposed to go to facilitation, I think January 29th, that be extended as well, correct?
Connor, that's up to you, but we did file it to concur, Your Honor.
Right.
That is correct.
Oh, okay.
If I may, Your Honor, We aren't asking for the facilitation to be adjourned. We still plan to do the facilitation on 129.
Okay,
It's just that in the scheduling order, there was a deadline to have completed the facilitation by then. We obviously just don't want to be not following the court's orders, so we just wanted to extend that deadline.
okay. So you're looking for a deadline, how far out?
If you wanted to put it to February 1st, that's fine by me.
Okay. Mr. Ipsy, is that good for you?
Yeah, that's fine.
All right, motion is granted. Discovery and facilitation to be completed by February 1st, 2026. All right, you can submit an order.
Thank you, Your Honor.
You're welcome. Have a good day.
I have
too.
February 26th, Your Honor.
I thought you said February 1st. Did you?
As to the discovery, as to the deadline for facilitation, if we could get the 45 days, we would appreciate that. I apologize if there was confusion.
Is that for the discovery?
Correct, Your Honor, the 45 days for the
Okay.
discovery and the
And what date,
MSDs.
and what date would that be?
So if we were to do today, let's see.
Would that be February 27th?
So that's 7, 14, 21, 28, 35. Yeah, February 27.
All right, discovery continues to February 27, 2026. Facilitation to be completed by February 1st, 2026. Anything else?
And can we just include the summary disposition cutoff in the 27th?
Yes.
Okay, thank you, Your Honor. We'll submit an order to that
All
effect.
right. Have a good day.
Thank you, Your Honor.
You as
Take
well.
care. Take care, Connor.
You as well. Thanks.
Calling case number 25001-835 NF SNM Physical Therapy LLC versus Cure Auto Insurance.
Anyone here for SNM Physical Therapy? Kim, you can cancel. It was a show cause hearing.
Calling case number 25001-598 PD Public Service Credit Union versus Kawana Morton.
Good morning, Your Honor.
Yes.
Michael P. Mamet, PA 1102 on behalf of plaintiff.
And Ms. Morton, can you state your name for the record?
Yes, Judge. Hello, good morning. I am Kiwan Morton.
All right. I'm going to send you both to a breakout room so that you can discuss. When you're ready to come back, just return back to the Zoom conference room.
Thank you, Judge.
You're welcome.
Your Honor, I don't mean to interrupt, but I was here for the Conform Chiropractic, which you call as S&M Physical Therapy.
Okay,
That
well,
was for the show cause motion.
okay, but did you answer? No?
Well, you had called it as the,
I'm gonna kind of move on and then we'll return back to your matter.
all right, thank you, Your Honor.
All right. Kim, you can call the next case.
Thank you, Judge. Calling case number 24016-133 NF Sean DeGolda et al. Versus the Hartford Fire Insurance Company.
Morning.
Good morning, Your Honor. Eric Johnson appearing on behalf of defendant Hartford.
Morning, Your Honor. May it please the court, Larry Lieb appearing on behalf of Nagoda and Slade, the plaintiffs.
All right.
Your Honor, Mr. Johnson and I spoke this morning. I believe he's going to withdraw his motion. We need some additional discovery time. We actually have, we had case evaluation back, I believe, in August.
August 13th.
Yep, it didn't resolve the case, but I believe that we're going to enter into a facilitation. But we need some additional time. The court scheduled a settlement conference for next week. And rather than taking up the court's time this morning, I think we probably address it then.
Okay, it seems to me I already entered an order for you to facilitate. Right?
I'm not sure, Judge. I don't have that in front of me.
You know, I entered an order, you were supposed to facilitate, so now you're telling me that you didn't facilitate, so you want to extend it out further. So how much further do you need this extended? Because it doesn't seem to me a lot is going on with this case.
No, Your Honor, that's correct. There's some discovery that needs to be done. We have depositions. We noticed depositions, they need to be rescheduled. There's an issue of workers' compensation documents regarding this claim. that we don't have. I was going to ask the court for either 60 to 90 days, and to facilitate by 90 days and have discovery open through facilitation.
I'm comfortable with that too, Judge.
Well, I entered an order back in September 25th, 2025, in which you told me that you were going to facilitate and that the facilitator was going to give you a number, accept and reject. That would be January 19th. So you're telling me that you didn't take care of that.
That's correct, Your Honor. Did not get facilitated.
Okay, all right. I'm going to schedule you for trial. I don't have a lot of confidence that you're going to, comply with a court order since you hadn't done it a little while ago. So pull out your calendars. I'm looking at March the 23rd.
But I'm looking right now, Judge.
All right. And then if you want to facilitate, you're free to do so.
That's fine, Your Honor. March 23rd.
All right. Anything else?
I believe I'm okay on the 23rd, Judge.
All right. Your matter is going to be scheduled for trial. If you want to have another settlement conference with me, if you'll contact my office and let my clerk know, I can usually get you back on a Zoom conference within 7 to 10 days.
So is the court canceling next week's on the 21st?
Yes, I am.
Okay. So we're set for trial on March 23rd at 9 o'clock for you. And if we settle it earlier,
You can just call the court and let us know.
okay,
All right.
that'll work. Thank you, Judge.
You're welcome.
Thank you,
Have a
Rheta.
good day.
Eric, I'll call you in a few minutes.
Sounds good. Thanks, Larry.
Okay, bye.
Calling case number 25007-551 NO. Latoya Watkins versus KMG Prestige Inc.
Michael Crow appearing on behalf of the defendant.
All right. And this is your motion?
It is, and we have an agreement. I spoke with plaintiff's attorney yesterday to submit a stipulated order requiring discovery responses within 21 days, a date for the taking of plaintiff's deposition within 21 days, and they are in agreement to the requested adjournment from track 1 to track 2 as long as the court is.
Okay. Not a lot going on this case either. I noticed that according to your motion, plaintiff hasn't filed the initial disclosures, hasn't filed an answer to any of your discovery requests, failed to appear for a deposition. I will grant your request to move you to track 2. Now on track 2, the witness list is due January 27th. Discovery cutoff would be March 31st, and case evaluation month will be June 2026. But got to get the discovery done. If not, I think plaintiff's heading for a dismissal.
If I could do both sides of the V, I would, Judge.
I
It'd be
know,
much
I
more
know.
efficient.
I know. All right. Have
All
a
right,
good
thanks,
day.
Judge. Have a great weekend.
You too.
Calling case number 24006-907 NI. Rashonda Robinson versus Etta DeHines et al.
Morning.
Good morning, Judge Paul Wheatley on behalf of plaintiff.
Good morning, Your Honor. Daniel Mentier on behalf of defendant Cure.
And good morning, Your Honor. Christopher Jennings on behalf of the defendant Hayes.
All right. We have several motions up today, but probably the one that I need to address today is plaintiff's motion to adjourn the trial 30 days.
And yes, Judge. And then the other one, I agreed with sister counsel on the not bringing up, bills or the insurance. So those ones shouldn't be an issue either. The main one is the motion, excuse me, to preclude the police report. Excuse me.
Okay. Well, I would think the main one would be the motion to adjourn trial, right? Is that not the main one, or?
You're absolutely
am I missing
correct.
something?
I believe the police report would help with maybe settling or not settling as well, but maybe I'm wrong.
Okay. All right. Well, Ms. Wheatley, that I always ask all the lawyers that come before me, is this date a good date? Now, I expect everybody to have their calendars out, have their children's calendars, their wives' calendars, grandparents' calendars, so that way when I give you a date, I know it's a good date.
And you absolutely did. And then I left that day and I punched myself in the face figuratively.
All right, and I imagine that your family is starting to get rather hostile with you when you mention to them that you have a trial, right?
That's always the case, yes.
All right. Well, to avoid you getting a divorce, I'm going to grant your motion to adjourn the trial, especially because it looks like your file date is in May, so I've got a little bit of wiggle room there. Okay, you guys, do you have your calendars out? I mean, your wives' calendars, children, grandparents?
I have every calendar I could possibly have. Thank you.
Okay.
Your
look-
Honor.
Yes.
Sorry. I was just gonna say, I believe there was a concurrence filed by co-defense to adjourn to the end of April. And there was also, I believe, a motion to bifurcate as
Yes.
well.
Well, let me take care of the motion to adjourn trial first. Let's get that out the way. So you're looking for the end of April?
Yes,
yes,
trial
Ron, I would be-
counsel filed a concurrence and indicated that she's on spring break the week of April 2nd through April 10th. So
Okay.
that was the only conflict, I guess, in April.
Okay. If this goes forward to trial, how many days of trial do you think you'll need?
Potentially 5 with the liability issue.
Okay, because I was looking at April the 20th, but I noticed on my calendar that the No Fault Summit is that Thursday and Friday. Do you plan on attending that, or this is so old hat for you? You guys probably train, right?
Right.
Well, you know what? Just so that you have an opportunity to go, why don't we push it down to the last date? What about April the 27th? April 27th, 2026. Is that a good date on everybody's calendar?
Yes, Judge.
Yes, Your Honor.
Yes, Your Honor.
All right, now just keep in mind that, this is right up against the 2 years mark, so I'm not probably going to be as agreeable if you want to adjourn it. So
Thank you.
that's taken care of. Your motion to adjourn is granted.
Should we do an order, Judge?
Yep, you can
Okay.
do an order, but I'll send out an amended trial notice. They'll give you all the dates for the final pretrial conference and all of that.
Thank you.
All right, next motion to bifurcate the trial.
Yes, Your Honor, that was our motion.
I'm sorry, did you want me to hear that now, or do you want to wait until in April? Are you still talking about settlement?
I guess I'm not entirely sure where we are, Paul, on settlement negotiations. I was covering these last minute for trial counsel. She had an emergency that she had to take care of, so I'm not sure. I didn't get a chance to talk to her. I'm happy to handle the motions now, especially if it means we need 2 trial dates instead of 1.
Okay,
True.
okay, all right, go ahead.
Your Honor, this is a motion to bifurcate, essentially to sever the liability third-party complaint from the PIP complaint. As Your Honor knows, those 2 claims have different burdens of proof, different standards for proving injuries. It would certainly cause the jury some confusion to make a decision as to whether or not no-fault PIP benefits are entitled or properly payable, as well as deciding fault in whether or not the plaintiff sustained a threshold injury. With that, I'm sure that Your Honor has handled this motion a number of times, and I won't belabor the point beyond that.
Okay. Response?
Judge, thank you, Judge. I did a PIP and a UM trial in Judge Hughes' court a few years ago, and the jury handled everything well and was not confused at all. And most of our juries these days are pretty sophisticated, and I don't think it's an issue. And it would be an extra trial date and make the plaintiff try the case twice.
All right, anything else?
Your Honor, we would just point we believe that the bifurcation would actually impact the PIP side because of the 2 motions in limine regarding the references to insurance. If the PIP is in, then it would be almost like a contradiction to not allow to talk about insurance, but also have a PIP side where there's an insurance policy. So it would be kind of paradoxical a little bit. So we just think that that would be an issue. So we do leave that up to the discretion of the court, but we just point out that it would just make it really hard to allow the motion or grant the motions in limine regarding the insurance references, while also having a PIP side, because then how can you talk about insurance when there's insurance? Because it's been precluded. So that we would just point that out.
Okay, anything else? All right.
Thank you.
May the record reflect, I've had an opportunity to listen to defendant's motion to bifurcate the case. This is going to be a PIP and a third-party claim. I don't see a problem with trying both cases. It's more efficient, not only for the court's time, but also for the attorneys. So your motion to bifurcate the case is denied. Next motion is motion in limine to exclude police report.
Yes, Your Honor. The motion to exclude the police report, again, I'm relatively confident that Your Honor has heard this motion before, so I won't belabor the point on this one either. Essentially, we're seeking to exclude the police report. As you know, there's a statute on point that talks about the actual report itself should not be available for use in a court action, but shall be for the purpose of furnishing statistical information. In terms of plaintiff's response to the motion in limine, I think that the determinations on the hearsay evidence, if they can establish the necessary foundations to have that information admitted at trial without physical admission of the police report, I think that's fair game as long as those proofs are, properly laid and foundations laid at trial. So the motion is directed mostly to exclude the physical admission of the police report into evidence at the time of trial, and MCL 257.624 is on point in that regard, Your Honor. With that, I'll leave it to plaintiff and the court's discretion.
Okay.
Yeah, the main issue in this case, Judge, is liability. As my motion says, the defendant says there's a police report that says the defendant was trying to beat the light, and then the defendant herself went and changed the report. There's still a hazardous action on both reports to the defendant, and we've given you some case law that says hazardous actions are helpful to a jury, that the police report could come in under a business record exception 803(6), and then the statements themselves, likely 3 different ways that they get in under the hearsay exceptions. The present sense of impression, she said it when she was there, excited utterance. She was at the scene, was just involved in a big crash. And then that was her then existing mental and emotional state of mind. So, and then all of a sudden it's changed in the second report and then in her testimony to us. So we think it has some very good exceptions that get that statement in. And the statement is in the police report, which is a business record. Thank you for your time.
Okay. May the record reflect, I've had an opportunity to listen to oral argument. This is defendant's motion to exclude the police report. A police report is hearsay, and I don't believe that it is admissible. So I'm going to grant the motion. However, with regards to this, is when you file your final pretrial order, it can't be admitted as part of that. However, as we go through the trial and I hear testimony from the police officer or the plaintiff, at some point in time, there may be an exception that would allow it. But at this time, I'm going to grant the motion. All right. Next one is motion in limine, defendant's motion in limine to prohibit reference to insurance. And I thought there was a concurrence on this one.
I emailed my concurrence as to the BI defendant.
Okay, so that one is a stipulated order granting the motion.
It
So
would just be denied as to cure, right?
as to cure, right?
Yeah, so it'd be admitted as to granted as to defendant Haynes, but denied as to defendant Cure. Am I correct?
Yes.
Thank you.
All right, and the final motion? Is that a motion to limine to exclude any and all evidence, including testimony and exhibits of plaintiffs receiving personal injury protection benefits?
I agreed on that one as well, as to defendant Haynes.
Haynes. All right.
Yeah, and Your Honor, and I guess, Paul, we can touch base if Nikki isn't back in the office soon. But we can put those to orders or just reach an agreement and make sure that we include it in the pretrial plan and all that stuff. So
Sounds good.
All right, and just let me check. I don't have a settlement conference in this matter. It's just going to be scheduled for trial. Do you want to come back in for a settlement conference maybe in 30 days or maybe 30 days before the trial date?
I'm fine with that, Your Honor.
30 days before trial, I think would be,
You helpful? Okay, let me look maybe the end of March.
The that's the Royal Oak School spring break, but I'll be available the week before.
What about March the 26th? That's a Thursday? Come in at 10?
I think that works for defense, Your Honor.
Oh, yeah, the 26th? Yeah, that's
Yep.
fine.
March 26th, 2026, 10 a.m. via Zoom. If at some point you think it'd be helpful to come in person, just call my office and let my clerk know.
Thank you.
Anything else?
just a housekeeping matter, I suppose, to make it easier. Your Honor, would it be okay if I just prepared one order granting plaintiff's motion to adjourn and then addressing the other motions in limine? And I can send it over to Paul and to Daniel beforehand so we can just make sure it's all clean. That way we don't have a bunch of orders
Yes,
going around.
yes.
All right.
Just send
I
it
will.
around and you all take a look at it and agree with it and sign the bottom of it and then just forward it to me.
Perfect.
Thank you for the
Okay,
time today.
all right. Have a good day.
Thank you, Your Honor.
All right, recalling case number 25001-835 NF SNM Physical Therapy LLC versus Cure Auto Insurance.
Good morning, Your Honor. Kevin Layler on behalf of Cure Auto Insurance. I apologize for not ringing in earlier. We have the case listed as conform. I know that it's been consolidated with SNM, and that was my mistake.
Yeah, no problem. It seems to me the conform one was closed out when it got consolidated.
Yes, it was, and sometimes just the way the files at the office go,
No, I understand. But today is on the SNM Physical Therapy versus Cure. It is a show cause hearing for, is it Dr. Alan Dorr?
Alan Dore, yes, Your Honor.
All right. Have you had any contact with Dr. Dorr?
No, we haven't. I do know that the service on this was personal on January 8th, 2026 at 6:01 p.m. But apart from that, there's been no other contact that I've had with anybody or anyone else
All
on
right.
this file.
So what are you asking the court to do at this time?
We're asking to strike the testimony of, we're striking from as a witness, Dr. Dore.
Okay. All right. I'm going to grant that request. So Dr. Dorr is going to be stricken and not allowed to testify.
Very good, Your Honor. Thank you very much.
You're
I
welcome. Have a good
appreciate
day.
the grace. Thank you.
Right. Mr. Mahmood, are you ready?
Your Honor, I am. It doesn't look like the defendant's out of the breakout room.
Wait a minute. I've got a Zoom user, so I think, is she in the breakout room?
We were. I don't know if she got out.
Wait a minute. Let's see. Let me try to get her back. Sir, can you unmute your microphone?
Yes, Your Honor.
Okay, can you tell me what case you're here on?
Jace Grant.
Chase Grant. Chase Grant. Let's see. That is scheduled for 10:30. So do you want me to send you back to the waiting room or do you want to leave and come back?
You can send me to the waiting room so that way I can just still be already connected. Yeah.
Okay, let me change your name. And you are?
Turhan Grant, the father.
Okay. All right, Mr. Grant, I'm going to send you back to the waiting room. Don't leave. As soon as your attorney arrives, I'll bring you back in.
Okay, thank you.
Okay. All right. Ms. Morton, are you here?
Yeah.
There you go. Okay. All right, we're on the record with case number 2500159 PD, Public Service Credit Union versus, is it Kiwana?
Yes, Judge Kiwana.
Oh, Kiwana, all right. So counsel, you've had an opportunity to speak to Ms. Morton. How did we do? This is a show cause hearing.
Yes, good morning once again, Your Honor. Michael T. Mamet, P81102 on behalf of plaintiff. Your Honor, I had the opportunity to discuss the show cause with the defendant while we were in the breakout room. However, I asked several times for the location of the vehicle. She's refused to this point suggest that she either has it or doesn't have it, give me a location or anywhere we'd be able to pick it up. So at this point, I'd let the defendant explain herself to the court.
Okay. Ms. Morton, I'm going to ask you to raise your right hand. Do you solemnly swear affirm testimony about to give to be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor, I do.
All right. Can you state your name for the record again?
Kiwana Morgan.
All right. Now, Ms. Morton, this is involving a 2019 Lincoln MKC that was purchased by you some time ago. Apparently you defaulted on the payment, and as a result, the Public Service Credit Union filed this action, seeking recovery of the vehicle as well as for a default judgment. Now, default judgment entered against you in the amount of $25,851.40, and it also required a return of the vehicle. Are you aware of that, correct?
No, Your Honor.
No? Oh, okay.
No, I was never served anything, and I received this paperwork that I'm even supposed to be here. But that's all I've received thus far. I never received anything as far as returning the vehicle. And I will also like to say that this isn't a matter where I've taken off with a vehicle. This is a matter where the dealership has defrauded me as far as the vehicle is concerned. So I was going to ask for an adjournment as I seek counsel. I have made contact with their attorneys multiple times, not just to ask them if it's a way that they can work this out, but to ask them why wasn't and have it my warranty been honored. The vehicle is disabled. It has needed a motor. It has needed a trans. They have never honored me of my warranty, which I paid over $2,000 for. The vehicle I drove for 3 months, and then the dealership had to have the vehicle for 6 months of that time. And then when I did receive the vehicle back, I probably drove the vehicle, I don't know, just a quick guess, probably about another 6 months before there was more problems. So the problem here is that they haven't been honest with my repairs, and that then once I needed repairs of the amount of $3,000, I reached out back and forth. I still have emails with me reaching out in my communications per the attorneys and the Public Service Credit Union.
Okay, but you didn't buy the vehicle from the Public Service Credit Union, correct?
I bought the vehicle from Lincoln dealership.
Okay.
I refinanced with Public Service Credit Union.
Okay,
Public
because
Service.
what I want to tell you is a lot of what you're talking about isn't with Public Service Credit Union, it's with the dealership.
No, Judge, it's with Public Service Credit Union, and that's where my warranty wasn't honored. That was the breakdown of me even falling behind in anything, because
Okay.
if
All
the
right.
motor is gone
Well,
and the trans.
then why not turn the vehicle in? Why not let counsel know where the vehicle is so that it can be picked up?
I never was reached out to again about as far as counsel is concerned. This is the first acknowledgement I had of
Okay.
even.
Can you give him the address where the vehicle is located?
Your Honor, I was asking if I can have an seeking counsel due to in fact, I have spoken with multiple attorneys. I just I'm asking if I can see counsel because
Okay, how much time do you need?
well, we have a very tragic situation going on. So for February, we will be in court. And I'm wondering what is the max time I'm really allowed. My reason of saying that is because we're already in January. In February, we have court. We have 2 abducted children in our family. All over, and so in February, I know that my mind is going to be,
Ms. Morton, I understand and I can appreciate that you're going through some personal issues, but this matter was filed before the court on February the 3rd of last year. A default judgment was entered against you. That was October 27, 2025. The time has gone by. If you're going to retain an attorney, you've got to do so right away. Because right now you are in default and there's an order compelling you to turn over the vehicle. And it doesn't seem to me as though you're willing to turn over the vehicle, because even if you get an attorney, whatever the issues are can be dealt with, but at this point, they're entitled to get a return of the vehicle. And I'm just missing why you won't turn over a vehicle that, according to you, isn't working, it isn't what you thought it would be, and it needs a lot of repairs.
Well, number one, Judge, I was, again, on the record, I never knew about any of this. And I've tried to make that clear. So I knew anything about this up until today. So I was not served any paperwork, and I knew nothing about a default judgment or anything. Again, I have made plenty contact with Public Service Credit Union. In fact, I was told 4/17 that of 2025 that they were working out a payment amount adjustment to better fit my financial situation, being as though so many things happen on their behalf. That is the last communication I had back and forth with their attorney, Alexis. So I'm asking, the reason that I'm seeking counsel is not about a runaway vehicle. It's about, they are the ones that breached my contract. They're the ones that didn't keep up their end of the bargain. And I'm on the hook for 24 grand. And that's not 25 grand, excuse me. And out of 25 grand, we still have a warranty that was never honored. The same day I paid, the same day I refinanced this car, 11/16, with Public Service Credit Union, I paid over $2,000 for a warranty. They canceled it the same day. It was never honored. All my repairs I was on the hook for, and that's how we're here with a vehicle with no motor, transmission and so on, and me having to come out thousands of dollars without my warranty being honored, which was supposed to be honored up to 103 miles.
Okay.
So they denied
anything you want to add?
Yes, Judge, if I may, the agreement that's attached to the complaint, it's page 8 of our complaint. It's the last page of the agreement. This loan was a personal loan that was given to the defendant. It's not a direct retail installment contract. So as the court noted earlier, any claim that the defendant has against the dealership, or any possible claim the defendant has against the dealership, has no bearing on the fact that she took out the loan through plaintiff. She owes the money to plaintiff. And one of the only or best ways that we can mitigate our damages is possession of that property and to put it for public auction. Under the law, it's commercially reasonable. As this court noted, the order's already entered for her to turn it over. She's failed to do so. She's mentioned a few times that she knew nothing about this. However, she just stated on the record that as far back as April, she's spoken to attorneys in our office. I read her a note from June of last year from a conversation she had with another attorney in our office. So to say that she knew nothing about this until she got the paper for today, I think is at best disingenuous. So I would just ask the court to once again either order the defendant to give me the address, to turn it over by Monday, or to find the defendant in contempt.
Okay. All right.
I'd like to say, if I may, that none of that is honest. None of that is honest. Okay, I understand he is a legal representation of Public Service Credit Union, and that's why I asked to seek counsel so that I can have proper representation, because nothing he just said was honest. And if I reached out again to them 4/17 of 2025, there was no discussion of a vehicle being returned at all. The discussion was, per our communication, they were working out a deal and that they were going to find out. I wanted to know, why wasn't my warranty honored in the first place? Because that's really how we got here, from me having to force out all the payments for all my repairs and them not honoring the contract. Public service not honoring the contract. I'm not talking about when Lincoln did. I'm talking about after my refinance with Public Service Credit Union, my warranty with Public Service Credit Union, not my warranty with Lincoln dealership. That is not the conversation here.
Okay.
So I do not appreciate him making me out to be
That
lying, Your Honor.
doesn't make any sense to me that a credit union offers a car warranty. That just doesn't sound right to me. But listen to me. Be that as it may, you're going to have to get legal representation. I'll give you 30 days. I'm going to reschedule this matter for February 13th, 2026. At 9:30 a.m. via Zoom. If you don't have an attorney by then, I'm going to grant plaintiff's request compelling you to provide the address or return the vehicle. If not, you'll be held in contempt of court, which means that a bench warrant issues for your arrest. You don't want to do that. So if you retain an attorney, they need to file an appearance on this case and get this going. If not, then you've got to contact plaintiff's counsel and turn the vehicle in. You understand that, Ms. Morton?
I understand that, Your Honor. May I have another say here?
Nope, that's it. Nope, that's it. That's the time. That's the time you have to retain an attorney. All right, if there's nothing else, matters adjourned.
Thank you, Judge.
You're welcome.
Have a great day. Have a good weekend.
Thank you.
Thank you.